In Arvin, California in 2017, an employee was working on a large piece of equipment called a roll sizer at a carrot producer. And in maintaining the machine, this employee was a sanitation worker, reached in to grab some debris and suffered an injury. The California Occupational Safety and Health Administration issued a citation for machine guarding and a citation for lockout tagout. The employer, Grimway Enterprises, contested those citations and prevailed in having both of them vacated. We're going to discuss the defenses raised by Grimway Enterprises on this, the January 15th, 2025 episode of the OSHA 3030. Well, welcome everyone to the OSHA 3030. I'm Manesh, Rath. I'm an attorney at Keller and Heckman in Washington, D.C., and I engage in a practice involving management side occupational safety and health law. The OSHA 3030 is something we've been doing since 2013, and every 30 days we produce a 30-minute summary of a developmental area of occupational safety and health law. And I'm joined today on this really interesting subject, this interesting case, by my friend and colleague, Ben Idzik. Ben, welcome to the OSHA 3030.
Thank you, Manesh. Always a pleasure to be on.
Ben, as you know, this is an interesting case in part because it involves a defense particular to California, and in part because that defense has an analog of sorts with the unpreventable employee misconduct defense. Why don't we get into first what we're going to talk about today?
Right. Yeah, let's get into it. So we have, like Manesh mentioned, the case of Grimway Enterprises versus Cal OSHA. We're going to start by giving an overview of the facts of the case, and then proceed to discuss the two main citations, which was machine guarding and the lockout tagout. And then we'll do a deep dive into the independent employer action defense. And then from there, we'll discuss the Cal OSHA's decision on both of these citations.
Right. The California Occupational Safety and Health Appeals Board, which also engages administrative law judges like the U.S. OSHA system does. Finally, as we always do, we'll wrap up with some practical takeaway items for you, our members of the OSHA 3030 community, that you can take away from this program in a final section for what employers should do to make this all more meaningful and practical to you. Okay, so why don't we get into the facts of the case first? This is a case involving a carrot producer in Arvin, California, at the southernmost end of the Central Valley of California, the fruit and vegetable basket of the world. And in Arvin, California, there's a carrot producer, Grimway Enterprises. And I got to say, Ben, as you know, we represent not hundreds, but thousands and thousands of food producers worldwide. And so this is the kind of equipment that we have seen and worked with. The processor uses a machine called a roll sizer machine. And to understand how Grimway Enterprises produces carrots, you should imagine that it seems that almost everything about the processing is automated or automation assisted at the least. The carrots come into the facility and they are dumped from totes onto the machine process by automation, and then they are sorted in the roll sizer, a machine that shakes the carrots and using vibration puts the carrots onto revolving rods where it's sorted by size, and along the way the carrots are processed. The greens are separated. The carrot greens are separated. If the end retail product is going to be cubes or sticks, the carrots are cut to size. And in addition, the carrots are peeled and washed. And I should say that they're washed several times throughout the process, thoroughly washed. These are roots that are covered in greens as well as dirt, and they need to be washed very thoroughly, and the process is a very thorough one. Grimway Enterprises has a very sophisticated operation, but it also appears from the opinion to have a very sophisticated safety plan in place. So this machine, the roll sizer, it's a large machine. It's easily 50 feet long in one dimension and 12 feet in another dimension. And the carrots are placed onto the processor, and through using vibration, sorts the carrots onto revolving rods, which sends it through the rest of the process. Alongside the machines, Ben, as you know, there are two elevated working platforms, one on each side. These are like catwalks. These are the safe places for workers to position themselves, and they're restricted from going anywhere else on the machine. They're confined to the catwalks because those are safe locations.
These working platforms were used by sanitation workers and other workers in the facility. The events in this case start on May 26, 2017, where a sanitation worker who was stationed on one of the adjoining platforms left his designated work area and reached into the roll sizer machine to clear a jam without de-energizing the machine or without locking it. And as a result, was unfortunately and tragically injured because of his actions.
So this is a problem because the process that he was supposed to engage in, sanitation, which is almost always a third shift in the food industry, almost always a third shift task. It involves standing on the working platforms that I described earlier. And part of the tasks of sanitation would involve hosing down these rollers, these revolving rods. And to do so, the machine has to be running so that you get all sides of a revolving rod under the spray of the hose, and thereby get all of the debris that's attached to it washed down. But if you see something stuck, like carrot greens, or in this case, I think he saw a piece of plastic jammed in there between the rollers, then you have to turn off the machine, de-energize it, and then lock out the energization source, and then remove the debris or jam, and then remove your lock, and then re-energize the machine, and continue with those parts of the task that require energization, like hosing down the rollers. Okay, let's move on. So Robert Salazar has been injured in this process, and as a consequence, Grimway Enterprises conducts its own internal investigation, and Cal OSHA, conducts an on-site investigation inspection as well. And as a consequence of their inspection, Cal OSHA issues two citations, one alleging a violation of the machine guarding standard. And in it, OSHA alleged that since all machines and parts of the machine that create a hazardous movement must be guarded, that Grimway Enterprises violated that requirement by having a machine design such that a worker could access the zone of danger, the hazardous movement of the machine. And the evidence of this is the fact that, in fact, Robert Salazar did enter with a part of his body, his hand, the zone of danger. In addition, Cal OSHA issued a citation under the lockout tagout standard as well, alleging that the Cal OSHA lockout requirement is that moving machinery must be stopped, de-energized, and locked out during cleaning, servicing, or adjusting of the machinery. And that because Robert Salazar did not de-energize the machine and place his lock on it, and nevertheless entered the zone of danger with his hand, that constituted a violation of the lockout tagout standard. I should point out, Cal OSHA has the burden of proof to present evidence that these standards were violated. And it must establish this assertion of a violation of these two standards by a preponderance of the evidence, meaning that any evidence countervailing Cal OSHA's evidence must be greater in weight in its reliability or its probity, its relevance, than the countervailing evidence presented by the employer, here, Grimway Enterprises. So that is a description of the citations that OSHA entered. Let's take a look at what the administrative law judge said. First, let's talk about the machine guarding citation and the lockout citation themselves, and what OSHA argued and what Grimway Enterprises' arguments were. To begin with, we should talk about the machine guarding standards. So Cal OSHA, their allegation in their citation was this involved revolving rods, which clearly represents a zone of danger, and the rotation of those revolving rods should have been adequately guarded
Hmm.
by Grimway in order that employees could not possibly reach in and enter with any body part the zone of danger. And the fact that this employee, Robert Salazar, is able to enter the zone of danger with his hand is evidence that it was not properly machine guarded. A guarding should have stopped him from being able to do so.
And Greenway responded that yes, these revolving rods were rotating hazards, but they argued that they were guarded by the machine's frame, which was very large and should have prevented someone from getting into it through within their designated work area, and their rod's location, again, relative to the work area. So their argument boiled down to the fact that this was adequately guarded.
That's right. And the working surfaces present a part of Grimway's argument as well. When they say that the location of the zone of danger was such that employees didn't have access to it, it was presumed in their argument that an employee would be standing in the proper location on the working surface, this sort of catwalk adjacent to the roll sizer. And not that they would be climbing up on top of the machinery or reaching upwards into areas that you shouldn't have been reaching into and couldn't have been accessed if you're standing in the proper working surface. So they were saying that based on the working location, it was impossible to access the zone of danger, and you would have to have climbed on top of the machine impermissibly and reached into places that you wouldn't normally have any reason to reach into if you were standing in the proper location. So that distancing or location was a form of separation that qualifies under the California machine guarding standard. In addition, as you say, the argument that the revolving rods were not a rotating hazard was premised on the framework of the machinery presenting a form of guarding, that form of guarding being to create distancing. So, so I think it's a sound argument. Let's talk about the lockout tagout standard next. California's allegation in the lockout tagout standard was that Grimway did permit Robert Salazar to clean the roll sizer while the machine was running, and that he was able to reach in and grab a piece of debris without de-energizing and locking out, and that is a per se violation of lockout tagout. Anytime an employer reaches into machinery and doesn't first lock out or tag out, Cal OSHA has stated that that's a prima facie case, at least, of a violation of the lockout tagout standard.
Right. And then Grimway's response was that they acknowledged the machine was not locked or tagged as required when the accident occurred, but they pointed to the fact that Salazar was trained on how to properly clean and lock and tag the machine out during those operations. So they argue that this boiled down to the fact that Salazar did not follow the proper training that he received from Grimway.
Right, Ben. And this is where the case gets interesting because what they're essentially saying is we don't contest that the standard, the lockout tagout standard applies, and we don't contest that the lockout tagout standard was not complied with, which is interesting.
Mhm.
What they're saying is we just have a case of an employee who was trained to do the right thing and didn't. So let's talk now, Ben, about what California law calls an independent employee action defense, a defense that the employee took independent action.
Right.
5 prima facie elements that goes into that?
That's exactly right. 5 elements. They all start with number one, that the employee had experience in the job being performed.
Then the employer has to be able to show that it had in place a well-devised safety program and that it trained its employees effectively on the contours of that safety program.
And then dovetailing off of that, the employer effectively enforced that safety program.
That's right. That enforcement part is really critical. And it's where a lot of employers fail in their defense in California's independent employee action defense. The fourth element that the employer has to show, Ben, is a policy of sanctioning employees, disciplining employees who allegedly violated the rules or requirements of the corporate safety program.
Right. And then the fifth one goes to the employee. The employee had to have caused the safety infraction that he knew was contrary to the employer's safety requirements.
Really, I think that last criteria is what makes it so exceptionally interesting. In California, in order to present a independent employee action defense, an employer has to show that the employee has to provide evidence that the employee knew that the act he engaged in was contrary to the safety requirements of his employer or her employer. And that, I think, is a really tough element to establish for employers. So let's keep going. The Board of Appeals, the California Occupational Safety and Health Board of Appeals, here's through an administrative law judge, here's both arguments, here's the evidence, and says, well, essentially, let's start with where the burden of proof lies. For OSHA to assert that there was a violation of the machine guarding standard or the lockout tagout standard, the burden of proof always rests with Cal OSHA. But if the employer raises a defense that there was an independent employee action, that is what's called an affirmative defense. And affirmative defenses are a specific and special species of defense. You can raise all sorts of defenses, but if you raise what's in a class called affirmative defenses, now the burden shifts from OSHA to the employer to meet their burden to present evidence by a preponderance of evidence in support of their affirmative defense. So it's a specific and special quality of defense, this idea of an independent employee action. So that's the first thing the court addressed.
Right. And then we get into the actual citations, which first begin with machine guarding. And the court here acknowledged that the revolving rods were sufficiently guarded. And to that point, they agreed with Grimway that the rods were housed within the machine's frame to protect employees that were working around the machine. And they were located far enough from the area that employees were in, their designated work area, that did not, again, pose a risk to those employees who were stationed there.
Yeah, so the court looked at the arguments by OSHA and by the employer, by Cal OSHA and by the employer, and agreed with Grimway Enterprises that the framework of the rule sizer and the walking working surface were such that the distance to the zone of danger was so great you'd have to reach into the machine and would not be able to access the zone of danger if you were on the working surface. But if you were climbing around the machine impermissibly, it would theoretically be possible that that's sufficed as adequate guarding.
Right.
It's interesting that they sided with the employer on that argument. Very important.
Yeah. The Cal OSHA board here did say, they, like you said, Manesh, they pointed to the fact that Salazar reached in to the machine to try to unclear a jam, and that's ultimately what caused the injury that he sustained.
Yeah, that's right. I think that this argument that the administrative law judge is crediting is essentially Grimway Enterprises' argument that he knew what he was supposed to do. He knew where he was supposed to stand, and on the working surface, on the rail, on the catwalk, and that had he done so, he would not have been able to access the zone of danger. And the fact that he lifted himself onto the top of the machine, onto the machine's frame, was elemental in the court's decision on the machine guarding citation. Let's talk about the judge's decision on the lockout tagout citation. Ben?
Right. So the ALJ here did find that the independent employer action defense applied. And to that, he pointed to several factors, beginning with the fact that Salazar was experienced in the position.
He'd been working there for over a year.
Right. And he also worked on this machine about 40 to 50 times within the 2 months prior to the accident.
The other thing that the administrative law judge found was that Grimway Enterprises had conducted training on lockout tagout, and specifically that Robert Salazar had attended that training and understood the training. And Grimway Enterprises kept records, training logs, as well as the training content, the training materials. And in the training logs, there was Robert Salazar's attendance at one of those programs.
Right. And they also pointed to the fact that Grimway kept a host of on-floor supervisors within the work areas, and those supervisors made rounds to ensure that employees were in fact following safety protocol.
Now, that's interesting, Ben, because the supervisor on site at the time had just clocked in and was walking onto the floor. The prior supervisor was clocking out. So this is often the case. Ben, as you know, we represent not hundreds, but thousands of food producers around the country, California and in every jurisdiction. And one thing we find is that sanitation is a third shift activity, necessarily so. And so the shift was ending, the sanitation folk were working, and the new on-site supervisor was just entering, having just clocked in. And when he heard the accident happen, and I'm sorry, she heard the accident happen, and then raced into the shop floor and hit the emergency stop button. Cal OSHA argued that that was evidence that there was not sufficient supervision. The administrative law judge looked at the supervision schedule, the floor patterns, the walkabouts, the gambles, and credited Grimway Enterprises on the specific binary question: was there or was there not supervision with respect to compliance by employees with the safety requirements? And they found that the supervisors were overall engaged in supervision for safety compliance. What the judge noted was it's not a requirement that the supervisors see all things everywhere at all times, merely that there is adequate supervision, and that in Grimway Enterprises' case, there was.
Right. And then the next element that was discussed was looking into Greenway's their actual safety program and how it enforced that safety program. And the ALJ here found that it used a consistent system of progressive discipline to sanction employees for safety violations.
Man, that record of discipline is so critical, and it's where a lot of employers fail. They say that they have a policy, they say that they supervise and monitor for compliance, and that they would discipline if they saw any violations, but they have no records to show that they ever actually disciplined someone. And I think as a part of an on-site supervisor's walk, when they take notes about maintenance issues or other tasks that need to be done, things that need to be moved out of the way, they should also be taking notes on their daily walks of anyone who is cautioned, warned, re-educated, retrained, coaching and counseling, so that there is a record of all of those things, which qualify, by the way, as discipline, as long as there's a written record of it. That's really the critical part. And if an employer can show that, they have succeeded where many, many employers have failed in either in the California case, the independent employee action defense, or in the U.S. system, the unpreventable employee misconduct defense, both of which have this quality of you need to show proof that there was discipline for violations of safety rules.
Right. And then I think the last key fact in this case was the fact that Salazar admitted that he knew that reaching to the machine to clear a jam violated the safety policy of the company.
Yeah, it's so unfortunate, Robert Salazar's experience, and it's heartbreaking. My heart goes out to him and to any employee who ever gets hurt or injured on the work site. And yet at the same time, I would note that it is singular. It's rare for an employee like Robert Salazar to admit, yeah, I knew that when I was standing on top of the machine, I shouldn't have been. I should have been on the working platform. Or I knew that what I had to do for lockout, and I didn't do it. So I would not count on in California this fifth really tricky requirement, which does not exist, does not have a counterpart in the federal OSHA system, unpreventable employee misconduct defense. I would not count on you having the sufficient evidence every single time, the way Grimway Enterprises did here with Salazar's admission. However, I do think it serves as a interesting learning point that it is important when conducting your internal corporate investigation to try and get that evidence, if it is so exists, to try and get an acknowledgement by the employee that they knew that what they were doing was violating the corporate policy. And I think it's possible, maybe not every time, but I think that has to be a part of a thoughtful internal investigation in order to truly understand what happened and why. Okay. Ben, why don't we talk by way of wrapping up about what employers should do in light of the Grimway Enterprises case?
Right. So I think the first thing is again simple but very important. Provide training to employees on the job duties that require hazards. And again, like we talked about, which is critical in this case, document the employees' completions of that training.
Yeah, and I personally think that the gold standard for records for training is to test employees on their comprehension of their training, not just to train them and keep records that they attended the training, but also to keep records as to how you measured their comprehension of their training. Either a written test, or what I would prefer is to say, have the trainer ask the employee to perform the lockout process safely, for example, and to take notes that you observed the employee demonstrating through an exercise, an activity, demonstrating comprehension of the lockout tagout requirements. And that record, I think, will be, in addition to the attendance record, really helpful, so that you can say not only did he attend the training, but he understood what he was learning. or she understood what she was learning. The other thing I'd say is that the employer should maintain a written safety and health program in California, a comprehensive safety and health program. Is important, and even outside of California in the federal OSHA system, it is helpful to have a safety and health standard operating procedures. But the injury and illness prevention program, the Comprehensive California written program, is a critical part of the independent employee action defense. In the case of lockout tagout in particular, it is important that your lockout tagout procedures, your written procedures, be machine specific so that every class of machine, every type of machine has specific written lockout protocol for each class of machine.
All right. And another important point is to ensure to be consistent as an employer, to discipline employees based upon the standards that are set out in your safety program. And sometimes even in the cases of accidents and injuries, we want to be consistent at all times to be able to maintain records of that if OSHA or Cal OSHA citations follow.
Yeah, those are often the hardest ones to issue discipline when an employee's already been injured. You think to yourself, maybe the employee has learned their lesson, they've been punished enough by the injury itself. But I think it's critical to keep on record that the employee was advised that that was a violation. And to be consistent and uniform in disciplining, and as we talked about earlier, to keep that as a record of your walkthroughs, gambles, or other safety walks. And then finally, as we talked about, it's important that supervisors monitor for compliance and keep records of their monitoring activities, their safety walks, et cetera. All of those, I think, are the takeaway items that I would walk away from the Grimley Enterprises case bearing in mind, and would encourage all of our friends here in the OSHA 3030 community to learn from the Grimley Enterprises case, those 4 points. Okay, well, with that said, that is today's OSHA 3030. I want to talk about our sister programs, the Reach 3030, which is scheduled for February 12th at 10 a.m. Eastern, and the Tosca 3030, February 12th at 1 p.m. Eastern. And those are run, if your organization is responsible for compliance with Reach or Tosca, these programs are run by some incredible attorneys who do a great job of bringing extremely valuable information to members of our community who are responsible for compliance with those statutes. Our next program, the OSHA 3030, will be held on February 19th at 1 p.m. Eastern, always on a Wednesday, always at 1 p.m. Eastern. We look forward to seeing you on February 19th. And in the meantime, all of our programs for the past 12 years are housed at our website, khlaw.com/OSHA 3030. And you can catch them as a podcast, subscribe on your own podcast app. So it just drops in and you can catch it on your commute, or you can click through and watch the video with the slides and the video of us presenting through our website, khlaw.com/OSHA 3030. They're also found on YouTube. Just search Manesh, Rath, or OSHA 3030 or Keller, Heckman, and they should come up. Remember to like or rate the YouTube or podcast so that they're more easily findable by others who want to search for these programs. Well, on behalf of the terrific staff here at Keller and Heckman who helped put this episode together, and on behalf of my friend and colleague Ben Idzik and myself, thank you all for joining us on this month's, the January 2025 OSHA 3030. I'm Manesh Rath. We look forward to seeing you again next month, and until then, stay safe.